Hello, everyone, and welcome to Uncivil Law. For today's case, we have a situation where an attorney has clearly lost their mind. This is a case from the Court of Appeals for the Fifth Circuit. It is a case involving the Atacapa Indian de Croll Nation versus the state of Louisiana. In this case, the tribe, which is not federally recognized, is petitioning for some sort of recognition. Now, that in and of itself, of course, is not insane. That might be a very lucid legal issue, but the way this particular attorney went about it would not be what I would suggest is lucid, competent, sane, or good trial practices. I think you're going to see what I mean very rapidly, so let's get started with this. The plaintiff, a lawyer who styles himself both as a monarch and a deity, brought claims on behalf of an Indian tribe alleging that the defendants have, among other misdeeds, monopolized intergalactic foreign trade. The district court dismissed the case based on sovereign immunity. We affirm on the alternate basis that plaintiff claims are frivolous and the district court therefore lacked jurisdiction to entertain them. Monarch, deity, intergalactic foreign trade. We're off to a promising start. This action was originally brought as a habeas corpus proceeding by Edward Moses Jr., a lawyer who calls himself the trustee of the Atacapa Indian de Croll Nation. This group is not a federally recognized Indian tribe, and its precise nature is unclear. The initial complaint alleged that the tribe are being held as wards of the state through the Louisiana Governor's Office of Indian Affairs and are in pupillage under the United States and sought formal recognition as indigenous to Louisiana. The claims were based on a gumbo, nice touch there from Louisiana, I got the drift. The claims were based on a gumbo of federal and state laws, including 18th century federal treaties with France and Spain, as well as other sources such as the Pactum de Singularis Calcium, or the One Covenant of Heaven. The plaintiff subsequently filed something resembling an amended complaint, which sought to reclassify the action as a libel suit under maritime jurisdiction. Maritime jurisdiction. So we're now in some sort of sovereign cit land where we're going to talk about maritime for some reason. I don't know why maritime could even possibly be relevant to this, but sure, let's throw in maritime jurisdiction for no reason. The United States and Louisiana moved to dismiss, arguing the district court lacked subject matter jurisdiction. Finally, the court issued an order finding the plaintiff's filings constituted potential violations of Federal Rule Civil Procedure 11 that would require impositions of sanctions on counsel. I think it might be potentially sanctionable under Rule 11, which does not allow for frivolous claims. Yes, I think that might be a rule that we could invoke here, yes. The district court dismissed on sovereign immunity grounds, but we need not go that far to resolve this appeal. The plaintiff's claims are entirely frivolous, and the district court therefore lacked power to entertain them. Some claims are so insubstantial, implausible, or otherwise completely devoid of merit so as not to involve a federal controversy. Unsurprisingly, we can find no Supreme Court precedent controlling or even addressing plaintiff's exotic claim. We must therefore ask, are the claims obviously without merit? We say yes. Why would you say yes that these proceedings are without merit? Would you like to tell us more about why these proceedings are without merit? Would you like to give us a color and flavor about why they're without merit? You would? You would like to tell us more? Great. Let's read on. The pleadings speak for themselves. To begin with, the tribe's counsel, Edward Moses Jr., who appears to be the real plaintiff, refers to himself throughout, using such titles as His Majesty, the Christian King de Orleans, the God of the Earth Realm, and Trust Protector of the American tribe of something in Hebrew, Moses. I apologize that I do not speak Hebrew, so I don't know what it says, but I'm sure it was just as lucid as everything else we've been saying up to this point. The plaintiff's claims are no less bizarre. For instance, the original complaint alleges, without any explanation, that the tribe are being held in pupillage by the United States and are wards of Louisiana. The first amended complaint seeks declaration of rights guaranteed by the 1795 Spanish Treaty with the Catholic Majesty of Spain and the 1800 French treaty with the former Christian majesty of France. The purported Second Amendment complaint attempts to name these additional defendants. Additional defendants beyond the United States? Who else is implicated in this tribal issue? Who else? Let's see. The additional defendants would be the Secretary of the Interior, Ryan Zinke, Attorney General Jeff Sessions, King Felipe VI of Spain, Prime Minister Justin Trudeau of Canada, President Emmanuel Macron of France, Chancellor Angela Merkel of Germany, Prime Minister Theresa May of the United Kingdom, Pope Francis, President Xi Jinping of China, President Abdel Fattah el-Sisi of Egypt, Prime Minister Farid al-Sariri of Libya, President George Weah of Libya, Prime Minister Antonio Costa of Portugal, and President Donald J. Trump. Your attempts at your European expansion pact are duly noted. The same document also alleges that the United States and Louisiana seek to monopolize intergalactic foreign trade. This is no typographical error. The plaintiff continues to argue on appeal that defendants are attempting to monopolize domestic, international, and intergalactic commercial markets. I'm not really sure what intergalactic markets they are, but I presume they would be covered by the Commerce Clause. That would qualify as foreign commerce, I'm pretty sure. We will not try to decipher what any of this means. My heart is disappointed. I would like to decipher what this means just for my own education, but I understand. He says the word is moshi. That provides me no clarity. What does moshi mean? Or moshi, depending on how it's pronounced. Fizz, you got to help me. That does not help me. What does that mean? What is moshi or moshi? What is that? In the context of Moses. Does it just mean Moses or like... That provides me no color. Moses in Hebrew? Thank you. Yes, so it's just Moses in Hebrew. Okay, fair enough. I am now clarified. To do so might suggest these arguments have some colorable merit. Despite all this, jurisdiction would still lie if the plaintiff presented a non-frivolous federal question. We find none. There's not a non-frivolous question in this? My heart is sad. For example, the plaintiff asserts various antitrust violations, but he fails to allege any colorable basis for them. The best he can do is allege anti-competitive behavior by Thomson Reuters. How does Westlaw get into this? What are they doing to restrain the intergalactic trade? I'd like to know more. He seeks an injunction not to stop anything the defendants are doing to the tribe, but instead restrain the doctrine of discovery and doctrine of conquest, commonly known as the doctrine of white supremacy. Literally, what? Many arguments depend not on the alleged violation of any federal statute or rule, but instead the assertion that the 1803 Louisiana Purchase is not law of the land. What? Louisiana Purchase isn't law of the land? Okay. We could say more, and personally I really wish you would, but I understand. But the examples are enough to show the plaintiff's case are wholly without merit. The government should not have to be put to the trouble of responding to such spurious arguments, nor this court the trouble of adjudicating this meritless appeal. The district court lacked jurisdiction because the claims asserted are so attenuated and unsubstantial as to be absolutely devoid of merit. For the same reason, the district court did not err in denying the other motions affirmed. Well, that is the end of the case of the Apaca Indian de Crow Nation versus the state of Louisiana. In this case, we learned that an attorney who styles himself as Intergalactic Lord and all a bunch of other stuff. It's a long list. But he filed suit because Louisiana and the United States were improperly restraining intergalactic trade or something. Yeah, so that is the end of this case. And I don't know what we learned or anything, but at least it was entertaining along the way. And that is the end of this. So, yeah.